Hello, everyone. Thank you so much for attending. We're going to, I think, give it a few more minutes to wait for a few more folks to join us. So please be patient and thank you all for joining us. Am I everyone? Thank you for joining us. I think hopefully everyone can hear me now. All right, thank you all. We're just giving it one more minute to wait for one more panelist for Joe Mattal to join us, but we'll be beginning in a moment. And thank you all for being here. We are very excited to have you here and very excited for the discussion that we're going to have. All right, everyone, we're going to start with introductions, and we may pause in a moment to introduce another, but we're going to get started. So thank you all for attending. We are very excited for what's going to be a very riveting discussion about changes that are happening at the Patent Office and what they mean. I'm Alex Moss. I'm the director of the Public Interest Patent Law Institute. We're a nonpartisan nonprofit dedicated to making sure the patent system promotes innovation for the benefit of all Americans. Our panelists are here to share their expertise and insights and their views. So they're sharing the views that they have personally, not those of their employers or their clients. We are incredibly grateful for their time and for yours. So let's begin. I'm honored to introduce Julie Burke, who served the U.S. Patent and Trademark Office for many years, including as a patent quality assurance specialist in the technical units that review patent applications on pharmaceuticals and biotechnology. After leaving the Patent Office, she founded IP Quality Pro LLC and regularly provides expertise on Patent Office procedures and practices, gives talks and authors articles that have been published in many outlets, and has a forthcoming book, which I'm very much looking forward to reading. I'm very pleased to introduce Greg Maurer. Greg has been a partner in the patent prosecution wing of the firm Clark-Wist Sparkman, considered by many of us to be the champagne of patent prosecution firms. His practice focuses on computer-related and bioinformatics patent applications and open source software for entities big and small. Greg also has extensive technical background of his own in software development and regularly speaks on patent law and policy in the US and around the world, particularly in India. So we hope he'll share his expertise in the international realm as well. I'm personally very excited to introduce Christopher Suarez, who's one of my first colleagues coming out of law school when I was an incoming clerk and he was an outgoing clerk, and I was trying to absorb all that I could from him in a very short amount of time. Chris is a partner at Steptoe LLP, where he represents a wide range of clients in litigation and counseling in cutting-edge technology matters, particularly in computer-related and semiconductor domains. Chris has litigated, I think, everywhere where litigation happens: federal courts, courts of appeal, the Supreme Court, Patent and Trial Appeal Board, and administrative tribunals. He also represents clients on both sides, patent owners and defendants, as well as federal employees in whistleblower cases, including employees of the Patent and Trademark Office. Chris also writes and speaks extensively on cutting-edge technology, law, and policy issues, particularly at the intersection of the Internet of Things and artificial intelligence. I'm very honored to introduce Professor Melissa Wasserman. She's the Associate Dean of Research and the Charles Tilford McCormick Professor in Law at the University of Texas, Austin. She is a leading expert in the fields of administrative law, patent law, intellectual property, and health law. Her research has been published in many journals, including the Stanford Law Review, the American Economics Journal, and the National Board of Economic Research. Her articles on the impact of patent office procedures on patent allowance rates, quality, and drug prices have been cited in countless legal briefs, including many that we have filed. She also has forthcoming articles and research on those topics that we look forward to reading and to citing. Now, I'm going to pause just for one moment to see if we are possibly going to be joined on our end. Oh. We're hoping to have Joe Mattal is having some technical problems with Zoom, so we're going to begin, but hopefully he'll be able to join us very shortly. And to give you all a sort of sense of what's coming, we're going to have each of the panelists talk about an area of their expertise, and then going to open the floor for questions. There's also a Q&A section, so if people do have, oh wait, I think that we have Joe here. I think that we have Joe. I'm very excited about this. Wait. A lot of suspense here. Excellent. We are, I think, we have Joe Mattal here. If we were live in person, I know there would be like a robust round of applause.
Can you hear me, Alex?
I can hear you. I can hear you.
Okay, great.
Excellent. Last but certainly not least, I'm very excited to introduce Joe Mattal. He's a principal at Clear IP LLC. And prior to that, he served for many years at the U.S. Patent and Trademark Office, including as interim director and acting solicitor, where he participated in briefing, I think, about every major case involving the PTAB. Before joining the USPTO, Joe served in senior legal roles for more than a decade in the Senate Judiciary Committee, where he negotiated and drafted many key provisions of the America Invents Act. He's also the author of academic articles that have been cited countless times by me, among many others, including courts of all levels. So thank you, Joe, so much for joining us, and thank you, everyone. We're gonna dive in now because we've got a lot to cover. And first, I'm going to turn to Julie and ask you if you can tell us about the recent changes that have been happening at the Patent Office, specifically those that have been affecting patent examination that's the process where patent examiners review applications and give us a sense of what changes have been happening and what they mean for the patent examination process.
Certainly. First, I'd like to thank you, Alex, for hosting this roundtable and for gathering together people with very different backgrounds and points of view. But one thing I believe we all have in common is a great deal of concern about the state of the U.S. patent system and the need for some fixes. And I'd also like to thank the Public Interest Patent Law Institute for hosting this. And also would like to thank, I know we have folks maybe from Congress on the call. Appreciate you taking time out of your day to attend, but we also have inventors, people from the U.S. Patent Office and IP practitioners who've taken time out to attend this discussion, and I really appreciate the interest in the topic. As to your question, Alex, recent changes. My golly, I was in the PTO from 1995 to 2015, and with each administration change, oh my gosh, there were changes. The pendulum would swing one way or another till the next round came around. But to be honest, this change has been more dramatic, more impactful than any that I had ever witnessed. Typically, the patent office is very low on the executive branch totem pole for who starts to get new leadership, new directions. Sometime, in the fifth or sixth or eighth month, the president will pick somebody to head commerce. And then after that, 18 months in, we might get a new director, which meant that their time period to actually implement change was quite shortened. And there was long windows between each administration change where the core civil service rank just kind of took over and did what they thought was best for the agency. And so we're in a very different situation with immediately having a new acting director, Stewart, and potential and a nominee director, John Squires. And we also are in a very unique position right now to have a Secretary of Commerce who is keenly interested in IP matters. And this is very important for us. The timing could not be better. This is crucial. Another key thing that's going on right now, we've entered this new administration with a historically high backlog of unexamined patent applications. The last administration had a plan to hire their way out of the backlog, hire 1,600 new examiners in a year, unheard of for, the patent corps is what, 8,000 something examiners. That's a huge number of people to be bringing on board. The executive order with the hiring freeze, of course, stopped that in its tracks. The other thing that the agency had been facing is hiring was happening last year and the year before and the year before that at pretty high numbers. But the attrition rate in Patent Academy was running 40%, which was very hard to imagine where the error is. Were they hiring, as Commissioner Valencia Martin Wallace suggested in the last town hall meeting, not the right people? This time they're going to try to hire the right people when it opens up, or were people not suited for the job, just did not like it, or was there something with the training or the productivity that was driving 40% out? So those were two things we've come into this administration with. But with the hiring freeze in place, the backlog has not gotten any smaller. People are out there inventing stuff left, right, and center. We still have applications rolling in, and more than half of our applications are coming from overseas. That's not going to stop anytime soon. This means people are moving back in the queue as to when they can get their patent application examined. So that's what we're facing right here. The administration also offered lucrative, well, not lucrative, but layoff options. We'll call them the fork. Get on out of here. Here's a chunk of change. Get on out of here. And some of the senior examiners definitely have taken that. The management, the supervisory patent examiners, the RQUASs have also chosen voluntary early retirement. Maybe it just fit their plan. Maybe the culture is not what they want to be working with. Examiners just reported this week on LinkedIn that there are no more quality assurance specialists in TC 1700, 2400, 2600, 2800, 3600. Those are the technology centers in the chemical, electrical, and mechanical areas. And with no quality assurance specialists to provide guidance on specific things, training, assistance, helping applicants. It's going to be hard. The resources are disappearing. We've also got a other time ban for training examiners, which is hard when a large, more than half the patent corps is junior and needs training. And with no training happening, how will that affect how the patent applications are being processed? The primary examiners who would take on and mentor and train junior examiners are no longer given other time to account for their time to do that. So examiners now are entering art units with nobody but their supervisor to look after their work, sign off on their actions, and train them. If you go into technology areas that examine AI, 70% of the art unit is junior examiners, and there's only one SPE, and he's got 20 people, and he's got to actually review the work of 13 of those on the volume of work. It's just hard to imagine how this is going to go forward. Very difficult times. The office actions being received by applicants may be concerning. But I'd like to just wrap this up and come back around to the biotech chem pharma area where I examined. And some of the most distressing things I've heard most lately is cutting subscriptions to search services that maybe not the whole core needs, but darn, when you're in biotech chem pharma, you need to do a chemical search. You need to do a dialogue search. The non-patent literature searches are so much more important in those arenas than it just straight up patent application searches. And curtailing those subscriptions means that the patent examiners can't search and find the best prior art or search it in the efficient manner in which they were used to. It seems very difficult if you cannot quickly identify the closest prior art. I mean, that is the gist of the whole job, and that is how a patent examiner tries to survive the production system in the agency. So those were things that very much concern me. I heard that examiners are writing notes in the file saying, no prior art was found, giving the search tools available during the time allotted, meaning they know they could not do a proper search there then. And doubling it all up is the IT system very slow, very clunky, trying to review a patent application where you can only flip prior art references one every 20 or 30 seconds, waiting each. I mean, the examiners are darn frustrated trying to use the tools at hand to do a good job. And that was before all these other things have happened. I don't know if there's anything else you'd like me to add at this stage, Alex, but that's kind of my assessment of where we are right now, 3 months in.
Thank you. That's very helpful. I might just ask you to just clearly, you mentioned subscriptions being canceled. And so those
Oh,
are the subscriptions to, when examiners search, they can look at, other patent applications, and then they can look or had been able to look at things beyond patents, at publications. And it sounds like the databases or the access to the things other than patents, to journals, to research, that all of those subscriptions have been cut. Is my understanding right?
what I've understood that for in the field of patents, it's STN and CAS, that's the chemical abstracts, very important for the pharmaceutical area, that access to those have been cut, and dialogue, which is another one where you can get into the academic research articles, science, nature. It's a group where you can look at the non-patent literature. I understand access to those have also been cut, a belt tightening, money saving effort by the agency. I've also heard bubblings up that the examiners think this might be temporary and they might be able to get access back. It's kind of hard to say. The agency hasn't really told us ourselves what services have been curtailed at this point.
Thank you. Now I'm going to turn to Joe and ask if you can tell us about changes that have been happening that affect the Patent Trial Appeal Board, which is the entity that reviews patents when challenged by third parties. It also reviews decisions by examiners when those are challenged by applicants. And what's happened there in the past few months?
Just about as grim a story. To be clear, I have no idea why they're doing this. Like, what Howard Lutnick conceivably plans to achieve by degrading patent examination and then shutting off access to validity review. At the board, they've adopted a couple of new policies that basically, like make it very almost impossible to challenge a patent at the PTAB if you've been sued in East Texas or at the ITC. These policies are, controversial and, the subject of ongoing litigation, but Director Vidal somewhat moderated them, and she adopted a rule that, look, we're not going to forego a PTAB review because of ITC proceedings, for example. The agency acknowledged, the ITC doesn't have the authority to cancel the claims. Even if they find in that case it's invalid, it doesn't prevent the patent owner from asserting it, continuing to assert it in district court litigation, and they do. And she also adopted some exceptions that if you made a stipulation that you weren't going to raise any of the arguments that you could have raised at the PTAB in district court, then they would grant review. And she also had a rule that, look, regardless of anything else, if you present a compelling case of invalidity, we'll grant review. And basically, they've gotten rid of all those exceptions. So now ITC proceedings are once again a basis for cutting off a validity review. No explanation, just, they just did it. And then they got rid of the compelling merits exception. Even if you present a compelling case that the patent is invalid in your petition, they still won't grant review. And they also, they fiddled some with the trial dates, but they've gotten rid of Sotera stipulations. That was the stipulation that you won't raise in district. The concern was supposedly overlap. Patent owners are burdened by overlap and having to litigate in two forums. Well, the only reason you're litigating as a patent owner in district court at the same time as a PTAB proceeding is because you wouldn't agree to a stay. This is something that patent owners themselves wanted. The defendant will always agree to a stay, and if both parties ask for it, the court almost always grants it. But the idea was, well, because we need to get rid of this terrible overlap, at least stipulate that you won't raise the same issues that you could have at the board. And they've just modified the rule and said, now, even if you plan to present prior art in district court, that's, for example, like product prior art, something that you can't present at the PTAB, that alone also creates duplication, and we're not going to give you, we're not going to grant you you basically have to stipulate that you won't raise in district court arguments that you would not have been able to raise at the PTAB. And the worst part of this is it's all done retroactively. It's probably been like 12.5 FINTIV denials already. And these are for petitions that were filed last year. No one had any idea that the rules were going to change this way when these petitions were filed. It was just announced and, implemented that day. And, people are literally, the rules are just changing on the ground. And frankly, given that these things have been implemented this way and applied retroactively to pending cases, who knows what new rules are going to come up? I mean, this all, the way this is rolled out, it reminds me of the old game of Calvin ball that Calvin and Hobbes used to play, where every time something happens on the field, you change the rules, and now that's a penalty or a new zone. That's what it must feel like to these petitioners, rules that you just never heard of are suddenly being applied to you. To give another example, under Director Vidal, there was a decision that if you if there's a 101 decision against the patent that's on appeal, that isn't a basis for denying review. Just, I think last week, they denied review in a case where someone, had a 101 case on appeal. Whatever you think of the merits of these rules, the idea that something that was clearly allowed under the office's rules, yesterday, and especially when you filed your petition, is now changed on a dime. It's just chaos. And the practical effect that's emerging, again, I think we're getting close to 20 FINTIV denials. The practical effect is you can't use PTAB if you were sued in East Texas or at the International Trade Commission. And about 90% of the litigation at the PTAB is brought by, non-practicing entities, people who don't, make any products, provide any services, or contribute to the national economy. If we keep going down this path, you're eventually going to get, every major company in America with $1 billion verdict against it. and wealth being transferred by the manufacturers and job producers in this country to non-practicing entities, a lot of which is just pure litigation funding, to a bunch of rich people who just want to make more money off their money without contributing anything at all to, to the rest of the United States. Why on earth we are pursuing this policy, I really can't explain. I've never heard of Lutnick before he was picked as Commerce Secretary. The only thing that's known about him is that he had quite a few business method patents, which themselves are kind of an embarrassment to the patent system. And I guess that's just his mindset. Like the patent system is just this vehicle for extracting money out of the rest of the economy. We just again, like God knows what's going to come next. Everything that's happened so far has been applied retroactively with no notice to anyone. It just I was joking with someone like the next new memo could be that we're gonna base institution decisions and office discretion on the phases of the moon. Tonight when we're analyzing this petition, the moon is at 3/4 of its strength. That weighs somewhat in favor of exercising our discretion not to exercise review. Hey, you laugh. It's not any crazier than the rules they're implementing so far. So I'm just curious where this all ends. You have this administration that is championing this agenda of like strengthening U.S. manufacturing and reshoring, et cetera. Like I can tell you right now, like the people they're trying to persuade to like invest in auto plants and chip fabs are the people most burned by this. And this will, if this continues for any amount of time, it will direct investment away from the United States. You don't have to deal with this in any other country. No other countries don't even have jury trials or these crazy verdicts. Every other country that has a patent system lets you challenge validity in some competent forum. This is already being talked about in corporate boardrooms, and it will affect decisions about where people invest in capital if this goes on.
Thank you, John. I want to have followed up with one small question, which is Julie talked a little about the changes at personnel and sort of retirement plans and of examiners. And are there similar measures happening with PTAB judges?
There are rumors that they may rift the judges. There are about 20 to 25 judges, I think, who've already retired. That's not enough to shut down AIA trials. What's shutting down AIA trials is these new rules. You were sued by an NP in Texas. The new policy is you're not entitled to challenge the patent's validity. If they do a substantial RIF, you probably need about 100, 120 judges to conduct AIA reviews. And remember, like, this isn't any cost saving. 100% of the cost of AIA trials is paid through the filing fees. You have to pay about 50 grand these days, to get one of these proceedings. That covers the entire cost. There's none of this is coming out of any other user fees or taxpayers or anything. People are paying the full freight for using this proceeding. By the way, when you get one of these denials, they also do not refund your fees. You paid $50,000 to have an arbitrary new rule applied to you and no hearing on the merits. I think over time, this is going to discourage people from, after a certain amount of time, it's going to become clear you just can't challenge validity at the PTAB if you were sued in East Texas or at the ITC.
Thank you, Joe. That is very helpful, if not inspiring. I'm going to switch it to the other side, having heard from sort of the side of what's happening at the PTO to understand how that's affecting actual entities that deal with the PTO. So Greg, wonder if you can talk about what these changes mean for patent applicants. I don't know how much they've impacted you yet, but whether now or how you foresee it being impactful, in the not too distant future.
Yeah, well, just first I want to thank you for including me, and I'm really honored to be on this panel. I've read people's research and heard about your bios and just happy to be here. And I do have a voice. So yeah, I'm a patent practitioner. So I've been working with, on the other side from the patent office, trying to get patents, filing patent applications, getting notices of allowance, getting patents granted, doing some IPRs here and there for the past 30 years. And so I've seen, as others have said, the waves, the pendulum swinging. But I think that might be helpful for me to talk a little bit about just what is a patent. And I think it's kind of deceiving because I think everyone on this call kind of knows what a patent is. And if you ask ChatGPT, it'll give you this answer, a patent it's a government granted monopoly, blah, 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 blah. But really what a patent is an elaborate gifting system, right? The whole idea is that the applicant approaches the patent office and applies for a patent. And they give us a description of the invention so that someone can make and use the invention. And in exchange for that, we give them the patent. And so then the next generation, when the patent expires 20 years from now, all that technology is free and open for everyone in the world to use. That's the theory. And so, you know, you call it a patent, I call it a restriction. It's essentially the patent office is offering these restrictions. It's you can't do this, you can't do that, you can't do this, you can't do that. There's a little plot of intellectual property land that we say none shall pass. Okay, it's like a writ or a warrant. It has the force of law. The entire federal government will be mobilized to enforce that grant of intellectual property. So it's a very serious matter, and who represents the public interest in this thing? We better get it right. We don't want to grant patents improvidently, because if we do, then they don't encourage innovation if it's just being gamed. And if the patent system doesn't encourage innovation, then full stop, we should abolish it. That's not my opinion. That is the nature of the patent system, the reason for its existence, okay? And so if we're talking about laissez-faire and these other things, this is not that. This is a restriction on the public's freedom, a restriction on the free flow of goods in the marketplace based on this thing that's issued. So the hapless patent examiner is given an extremely difficult and important job to do, right? And we had better get it right, or else the system is going to be in big trouble. But here's the rub. Patent examination is excruciatingly difficult. I saw some notes in the chat about this. It's excruciatingly difficult, and even for those who can do it, it's for some people it's also very unpleasant. And famously, judges don't like to engage in the exercise. And let's not even talk about juries. And so that's why we had this PTAB backstop, because part of this process is to determine if it really is an invention is we have to get all the prior art in front of us. And I think people here know this, but I'm just going to go through this just so maybe to provide tools for when you are explaining it to other people so that we can keep the communication open. You have to get this so-called prior art. Everything on the face of the earth that has come before. It could be a PhD dissertation from Egypt. That counts as prior art. That has to be in front of the examiner, because we don't want the examiner granting a patent on something that's been done before. That's not innovation. So okay, so we have to give the examiner these tools and they have to do it. But it's impossible to have a perfect examination process. We've talked about quality, and we've done a lot to work on quality in the past decade. Offices around the world have collaborated. We've tried to figure out how to get the tools in front of the examiners, how they can do the examination, how they can get bite-sized pieces. We can do some more stuff there, I'm sure, to increase quality. But there is a limit, and it's not going to be perfect. That's why we have the PTAB backstop, because when these things become a controversy that's worth $1 million per side, which is any patent it escalates to that very quickly, that $50,000 looks like a big bargain, because then I can have the patent invalidated and we re-examine the patent. That's within the confines of the US Constitution. We can do it that way. We don't have to go before the jury. So that's the way the system is supposed to work. And I just want to emphasize how difficult it is to examine a patent. It just takes, and we were just talking about technologies like Gen AI and Internet of Things. It could be CRISPR, could be quantum computing, could be all these very difficult things. And we have to find the best and brightest people to take a look at, understand these things, get the prior art in front of them, and make a decision and represent the public interest. So, okay, a little bit of a high horse soapbox thing there, but that's sort of the way I see things. And I'm just telling you that so that you can communicate that to others, that the patent system is supposed to be this elaborate gifting system. And if it doesn't work, then there are problems. There will be backlashes, as has been just pointed out earlier. Which is the big tax on innovation. If we want to build a factory, we're going to be in trouble. Okay. So then like the practical aspects then sort of just like flow from that. What are the effects on pendency, reliability? Well, you can see, right? I mean, if we decrease the resources that are available to patent examiners, or we decrease the number of patent examiners, or we decrease their supervisors, then you either reduce the number of patents, which would be a reasonable thing to do. That would, we would get fewer fees coming in, and this would be a process, a plan that would take over patent office policy over a period of maybe years, where we could maybe reduce the number of patents. I don't have any opinion on that. That could be a way to do it. Or we reduce the quality. Nobody's saying that they would intentionally reduce the quality, but that's what's going to happen if we reduce the resources and we reduce the tools available to the examiners, or we reduce the timeliness, and then we have a pendency problem. And justice delayed is justice denied, right? I mean, if you're a startup or you're a university and you're trying to get your hands on some patent visibility so that you can have a licensee fund your project or fund your university to do more research, it takes years, as it did before. I mean, I remember out in the software field, 5 years to get a patent. I mean, we've been able to get that down, and around the world, we've been able to get that down everywhere. And India just did a full sprint last year to try to get through the backlog, so that now their patent system is a functioning part of the innovation ecosystem. That's what you want. Innovation, it doesn't play well with a system that takes 5 years to act. So anyway, and then difference for different types of entities. I mean, it really doesn't matter what happens. The large entities, the big players, will figure out a way to just buy their way out of it or participate or whatever it is. It's the true innovators, the small, medium-sized enterprises. They can't play that game. And if we have an unreliable patent system, it really doesn't play well for the true innovators. And then finally, differences from international trends. Like, so I do visit India, and one of the things they've done is they've incorporated, for example, traditional knowledge into a database. So now the examiners can look at things and search them in the databases. Examiners have a limited number of time, limited number of resources. If we put that database in front of them, they don't have the time to go make phone calls or call a university professor and try to figure out what's going on in the field, whatever. But that database is there, then they can reject the patent. So we want to increase the amount of resources available to examiners, possibly give them tools beyond what we even know of today, right, with Gen AI and other things. And let's think of another tool, another possibility that I'll throw out there is, what happens if someone uses ChatGPT to generate 150 patent applications in one night and files those? Are we going to be able to detect that and stop that? I mean, so there are like even new problems that are probably going to come up that we need to address instead of just cutting back and hoping for the best. Now, if it's some part of some orchestrated plan and we're moving to a different paradigm, now, okay, but I don't know what that paradigm is. I'm all ears. I'd like to hear, I'm open to any ideas and suggestions that people might have, but that's sort of it in a nutshell.
Thank you, Greg. That's so helpful. You covered so much, so fantastically. We're gonna switch to Chris, who I'm gonna ask you. We heard about kind of from the patent applicant perspective, but sort of once the patent's granted, how do these changes affect the people you'll deal with who are probably litigating, and whether they're litigating in district court or PTAB, what does the world look like in this new world?
Yeah, no, it's definitely an interesting new world. A lot of changes are happening. As you said, Alex, I have the privilege of having some clients on both sides of the V. So I work with plaintiffs. I also work with defendants. And starting with the defendant side, obviously, I have to advise clients now that there is a substantial risk that IPRs are not going to get granted, and other tools are going to have to be considered in the toolbox if you're interested in validating a patent. We've seen some of these rulings already. I think Joe already mentioned some of these sua sponte denials of institutions that have happened, that have vacated previous institutions. I saw a decision on April 1st that very aggressively applied advanced bionics to say that some of the same prior art was already before the patent office, therefore we're not going to institute. And that's something I wanted to comment on, is because there are essentially three doctrines, right? There's the advanced bionics, which is about the prior art considered by the examiner. There's the fintive doctrine, which is, going to the point about these other litigations in East Texas and other places and implications there. And then there's also the general plastics, which is all about follow-on IPR petitions and, maybe not having duplications and things like that. And so the advice I have to my clients is that these doctrines are going to be applied expansively. And if any of them apply, you need to really look at information in depth to make sure you're getting around them as much as possible. Now, I want to say, look, it's to some extent, we don't have all the data yet. I actually was just curious, so I was looking at the last 3 days, this week, and on the 21st, we saw 8 granted IPRs, 1 denied. On the 22nd, 2 granted, 5 denied. On the 23rd, 2 granted, 3 denied. So it's not as though it's like all deny now. I mean, there are some getting granted. So we kind of need to see the data and see how this plays out. And the point I wanted to make, which I think is the most important point, is about transparency, right? And to have a functioning, patent system and innovation, we need to know what the rules are. And obviously, with the whims of different administrations, Vidal put out guidance, Iancu had different guidance. The pendulum does swing from administration to administration. It appears now that the pendulum has swung a lot this time. But the principle I care about most is transparency, so that I can properly advise clients and predictability. And we have a lot of challenges with predictability in patent law, CEG Section 101. These are this is where it gets to the root of the issue. And I say that because I know Alex, we had talked about this. Like, I had the privilege several years ago of representing Judge Fitzpatrick, who had a proceeding before the MSPB. And this is all public information because an opinion came out in the MSPB, and he blew the whistle, on the fact that there was surreptitious panel stacking going on at the PTO and in the PTAB. And it wasn't disclosed, and their misrepresentations were made to the Supreme Court. And all this was behind closed doors, and no one knew about it. And so I mentioned that to say that, obviously a lot of things are happening right now that are not transparent. It's not clear why non-patent literature was removed from the ability of examination. And that seems to be troubling. But why is that? And so the lodestar to me is really transparency, so that we can have meaningful policy debates and discussions about this, and to ensure that things are not arbitrary, which brings me to another point. Joe mentioned maybe the shading of the moon dictates whether we have a, institution or not. Like, the APA is there for a reason. If things are arbitrary and capriciously done, they should be, not allowed. And so what I'm curious to see is to sort of see how this transparency plays out. If the public scrutiny from forums like this and discussions like this can kind of ensure we understand what the heck's going on, and so that we're able to have productive conversations, and if necessary, there might be challenges to some of these things, but we need that transparency. From my perspective of representing both sides, I can see arguments as to why, you might not want to have duplicative proceedings. I will say that I think there is something special about the jury system in this country. I think that is a unique feature of American law that is special. When I'm on the plaintiff side, I obviously, might prefer to have a jury decide my invalidity case than the PTAB. And when I'm the defense side, it might be the reverse. But, there is something special about that jury system, and there is an American exceptionalism there, that there is something to that. So it's an interesting policy discussion, and I'm excited to kind of just see how it plays out, and also just kind of see how the chips fall in terms of the data. But we obviously got to stay on top of the administration and make sure that there's transparency, because that is really troubling, that things are happening. Doge might be doing things that we have no insight into why it's happening, and that's a problem.
Thanks, Chris. That's helpful. I'm curious, actually, if you can, I don't know if how much you're aware yet, but if any of the changes that have happened in terms of how the institution process is handled, if there have been changes that affect the transparency of that process.
Yeah, well, it's obviously hard, you know, with some of the sua sponte efforts, that's obviously it feels like it's coming out of nowhere. So that kind of stuff is uncertain. There's obviously been some transparency into this new procedure that adds a bunch of briefing on the front end, you know, for the discretionary denial. So at least we have some insight into what that process is going to look like. But you know, in terms of what criteria they're going to apply and how aggressive it's going to be in terms of denying institution, you know, I don't know. That's why for my clients who are on the defense side who are filing petitions, you know, I'm very clear about the fact that, you know, these doctrines, like I said, general plastics, advanced bionics, Vintiv, and so forth, are going to probably be applied aggressively. And so you need to cross your T's and dot your I's on that. And actually, you made me think of one other point, Alex, that I had wanted to mention. You know, what are those other avenues as well? I'm really curious about how this impacts ex parte re-exam practice, for example, because that is always something that's on the table. Right now, there's a backlog there, though, too. And today's processes take 3 years typically to do an ex parte re-exam. And if you're cutting the examination core, you know, that alternative may not be there either. So that's an issue. And then another just point I wanted to raise, not that I have a strong view on it, is, you know, I've heard some grumblings from the administration that, oh, you can just do the post-grant reviews. And, you know, the post-grant reviews are obviously there, but a lot of patents are granted every day. And, you know, as someone, when I'm putting my defense side of the V hat on, it's you know, very hard to anticipate which patents are necessarily going to be asserted eventually, and obviously there's a limited time frame to file a PGR after patents granted. So so I say that to say that because I think part of the policy discussion needs to be what is the alternative, you know, to district court litigation, and what does Congress think that alternative should be, and what's the right balance between IPR, ex parte re-exam, post-grant review, and all these things. And that's a conversation that hasn't been revisited, I don't think, for some time. I think IPRs kind of feels like we're the only game in town for a very long time. And so, you know, what is that gonna look like? You know, and so that's a policy discussion. That's why we're having a policy roundtable.
Thank you, Chris. Very helpful. So having gotten a view from the kind of what's happening at the PTO and what that looks like to practitioners, we're going to turn to Professor Wasserman and ask if you can kind of tell us what these changes mean really for the patent system as a whole.
Yeah. So definitely want to thank the Public Interest Patent Law Institute and Alex for putting on this wonderful roundtable. So when I think of patent quality, I think there's really 2 dimensions, right? One is, are we sure we're issuing patents that meet the patentability standards or denying patents that don't? And the second is really timeliness of review, right? Why do we care about getting patents in a timely manner? Because patents are important, right? And you can imagine a patent on the cure for Alzheimer's and that being delayed a year, right? What a massive social welfare drain that would be on society. And so when we look at all of these changes that all of our panelists have been discussing, right? One, getting rid of or diminishing the examiner workforce, like, is just going to result in the increase of the backlog, right? They're not going to change the overall count system or the amount of time that examiners are likely spending on an application, right? So they're going to have you have the same kind of throughput, fewer examiners, right? Means they're going to be able to review fewer patent applications in a timely fashion. On the other dimension of kind of what people traditionally think about patent quality, allowing patents that meet the patentability standards and denying ones that don't, right? There's a lot of things that are kind of alarming, right? That our panelists have talked about. You know, so you just have to keep in mind the PTO is making 500,000 patentability determinations a year, right? First of all, we know they're going to make some mistakes, right? But the changes that are occurring are just ramping up the number of errors that are going to be made, right? You get rid of all the non-patent prior art. I don't, there's no rationalization for that, right? To just start allowing patents on things that are novel, for example, right? Or not novel, right? Things that we already know are out there, but you can't search the relevant prior art to reject them. And so if we just began to start making more errors and allowing invalid patents, that has a potential, a large cost on society. As Greg kind of explained, the patent system is really to promote innovation, right? By giving inventors a way to recoup their research and development costs for some time period. But there's a trade-off. There's a cost to society. We pay more for patented invention typically, or we have less access. And we're fine doing that when we're getting some innovative benefit out of it, right? That we wouldn't have gotten otherwise. But if we're just allowing a bunch of patents on things that may be not novel, then what those patents do are impose the cost of patents on society without giving us this innovative benefit, which is concerning. Right. And the whole concern about patent quality was really in part what led to the AIA and the creation of PTAB, right, which is this adjudicatory board at the US Patent and Trademark Office that is also, Greg kind of described as like a second chance to look at an issued patent. Did we make a mistake the first time? We know even if the examiners are working really hard, right, they're going to make some errors. It's impossible for an agency to make 500,000 decisions a year and not make some errors. So we created this board. Right. And the whole point was to have a cost-effective alternative to federal litigation. Why would we want that? Well, patent litigation is incredibly expensive in the federal courts. It's millions of dollars, right, to litigate a patent case. And so we looked around and looked at other countries, right? And Europe had this post-grant opposition system and others had well-functioning. And we thought this would be great, right? Bring this in. It costs a fraction of what it would cost to litigate, right? And allow you to have a cheaper, faster way to kind of challenge an already issued patent in a system that we know there are going to be errors. And so now what we've done is taken this system, cranked up the errors, right? Allowed more invalid patents and basically taken away the cheaper alternative to get rid of them, right? And to challenge them at PTAB, right? And so we're left with a system that I personally think is much worse off, right? Than we were before. And when we think about this in something like biologics or pharmaceuticals, right? Patents on pharmaceuticals are on average much more valuable than the average patent that's issued, right? And so if we're thinking about this, if I was designing, right, the patent system, I would pick those patents, right, and give more resources to those so we don't make mistakes on those to begin with, right? We're only allowing patents that actually meet the patentability standards and denying ones that don't. Because when we make mistakes, particularly in these areas where we have very valuable inventions, they're just much more costly to society. So to this extent that we're getting rid of like chemical abstracts, right, for our examiners and this like pharmaceuticals to be searching, right, it's really concerning, right, that because these patents we also know are particularly more valuable maybe than just the average patent, right, that the PTO is allowing. So those are just some of my thoughts, Alex.
Well, thank you. I'm going to follow up and ask you. So we talked about, cost efficiency and things like that. A lot of these changes are, being made in the name of cost savings and efficiency. And, how do they, measure up in terms of changes to the time examiners have to their access to non-patent prior art? How do those fare as cost savings mechanisms?
Yeah, I mean, so yeah, if you're looking at like the government, are we paying less for certain subscriptions, right? Because we got rid of non-patent prior art? Yes, but the cost to society, right, probably dwarfs that substantially, right? The cost to patentees, right, the cost to people that use the patent system, it seems like those costs well outweigh, right, just getting rid of non-patent prior art. And it's very difficult for me to think of who I don't know of any kind of constituency in the patent system that thinks getting rid of non-patent prior art is a good thing for patent examiners to search, right? I think everyone would agree that's a ridiculous thing to do.
And curious, just in terms of how the PTO's fees work. I mean, is there, are they like coming from Treasury or going to Treasury?
Yeah. So the PTO is self-funded, right? So they basically set their own fees, right? And they're supposed to set their fees to recover their costs, right? And so you know, the patent applicants are basically bearing all the costs, right, associated with getting patents in the system, right? And as they said, they've set the fees for PTAB basically at cost recovery, right? How the fees are set for examination, it's a little bit more like they're subsidizing some other activity as well. So when I heard, like, you know, they're just denying everything in institutions, that's a little kind of alarming if you're paying $50,000, right, which is supposed to be the actual cost to go through the PTAB proceeding, and then they're just denying it ahead of time.
Thank you. That's helpful. I'm curious, just when we're zooming in, is that you mentioned, you know, cost to society, and I know that you've, you know, done research, and if you can sort of talk about whether, like, the errors, particularly in the pharmaceutical space, if those do result in differences in, you know, say, like, drug prices.
Yeah. Yeah. So I've done some work, right, that particularly looked at if we gave examiners more time, right, or gave more resources to the PTO so they made less errors, what would that mean for the cost for society, and in particular in the pharmaceutical space? Because you can imagine if we allowed some low quality and valid patent that wasn't allowed, you might get generic entry earlier, right? And we're sort of able to simulate what that would look like. And right, the benefits seem to well outweigh the costs, right? The fact that these are really, you know, not allowing a generic to enter for a very expensive drug, right, would have substantial savings to the public, both in paying the lower generic price as well as having broader access, right, to meaning that more people could have access to the generic because it's priced lower. So my kind of research, right, I really strongly think that providing more resources to the PTO at the beginning, not to make as many errors, would be better off for society.
Thank you. And I guess just if you can give us just again a little bit of a sense of, like, when you say resources, what do you mean time?
Yeah. So I think, well, like right now it's like examiners, right? Prior art, I would put all of that back. But I also think the work that I've done has also looked at like how much time examiners got. I think that they could be getting more time, right, to make better decisions when they're at times when they may not have enough time to do a proper prior art search or to write up the rejections. And that would make sense. And so you could imagine funding that by increasing the fees people pay for examination. And in particular, if you compare the fees, that they're much lower here in the US than, for example, what you pay in Europe.
Thank you. I'm going to turn it to Julie to ask sort of what you think and how that measures up. But just make one note to folks is that here, if patent examiners aren't able to find the right prior art or to formulate an objection in the time allotted, the default is that they grant. So that's partly why the issue of time is so essential. Sort of the clock runs down, and it's not you know, it doesn't mean nothing happens. It actually means that an allowance of the application happens. But I'm curious, you know, Julie, listening to everything, and especially, you know, Professor Westerman, you know, what do examiners like need to get to do their jobs as well as possible, or even recognizing it's a world where nothing's going to be perfect. But, you know, what things really matter when it comes to making sure that, you know, they're making fewer mistakes and the patents that are granted are truly, you know, novel.
Question for me, yes?
Yes, yes.
Okay, I'll jump in here. Very interesting listening to everybody else's points of view. In TC 1600, that's the biotech chem pharma area where you know, a lot of non-prior art is necessary to determine compliance with 102 and 103. Also state-of-the-art under enablement. If those resources are being withheld or not as readily available as before, it is true the examiners will struggle to make those novelty and obviousness rejections. But in that TC, they have got 101 in written description, subject matter eligibility. They have plenty of other grounds to reject patent applications for. If they weren't able to do a proper search on most all office actions in that tech center include multiple grounds of rejection under different statutes. And I can imagine what we're heading into is time of churning, where you get your office action and the prior art's not fully developed or addressed. There's 112 issues for written description and enablement, maybe a 101 rejection for subject matter eligibility. And when the practitioner responds to that, gosh, maybe they'll have reinstated STN and dialogue, and the examiner at that point will do the proper search, apply the prior art. It's going to end up with delays and more rework, but I don't know that for a fact that this is going to lead to more biotech, chem, pharma patents rushing out the door right now. The Sunwater study showed that 8% of the issued patents had claims that should not have been allowed, but 18% of rejected patents had allowable claims that should not have been rejected. So quality kind of runs two different directions there. And the uncertainty, the unpredictability, the rule changing we're seeing happening here, effective rule changing. They're changing practices and policies as we speak. And yes, it seems rather retroactive or immediate or spontaneous. It's kind of a engage to disengage sort of situation we're facing right now. It's a very interesting time for policy.
And have there been any changes, like you mentioned them to me previously, changes made in terms of how patent quality is assessed going forward?
Oh my gosh. So I've written an article on Lake Wobegon since the implementation of the AIA PTAB trial and set up because we had bad quality patents. My work has shown that the quality element of the examiner's performance and appraisal plan has been significantly, systematically downgraded after each congressional hearing on what's our problem with patent quality. The next performance plan comes out with another downgrade to reduce emphasis on patent quality, which has to absolutely have an effect on patent quality. The examiners work towards their performance plans, and when the quality element that requires what they need to be doing to allow and to reject claims is eroded, there has to be an effect.
Thanks. And Joe, kind of going to turn to you and ask, talking about quality and sort of that as being one of the rationales for the AIA, and sort of how you see that being, what the status of that is going forward, and, what is in particular sort of the PTAB's ability going forward to do what the goals that were in that for creating it.
Well, the PTAB has somewhat of a feedback loop on quality. When when a patent was only recently issued and then gets canceled at the PTAB, there's kind of a natural like, okay, what went wrong? And I've heard indirectly like examiners are embarrassed by that. People ask questions, but the principal purpose though of PTAB proceedings wasn't to change examination. I mean, to change examination, you need to change examination directly. The reason post-issuance proceedings were created at the PTO was just a sense of a lack of expertise in Article 3 courts. I mean, this goes, the complaints from the courts themselves go back to the 19th century. There are Supreme Court decisions saying, gee, wouldn't it be great if we had some system of experts to really look at this stuff? It's just really hard to do. And, in some technologies, it just takes a lot to get up to speed on understanding the background technology. And then to go from there to doing an obviousness analysis, it just realistically, it just doesn't happen in a lot of cases if you don't have someone, with the expertise, patent cases in the US, they actually used to mostly be judge cases. As recently as like the late 70s, 90% of cases were bench trials. But there were Supreme Court decisions that kind of broadened the jury trial right. That said, even if there are equitable issues, you still get a jury trial. Have flipped that. Now it's about 90% jury trials, and you very rarely get jurors with any kind of technical expertise. And the thing I've always found most distressing about the way the jury adjudication of validity works is watching how trial lawyers prepare for it. And there's this intense focus on like narratives and themes and stories, and you try to build up like who the different actors are. So if you're the plaintiff, you want to emphasize, oh, this is some big bad company, that has a lot of money, so this doesn't mean anything to them. And then if you're an NPE, you try to hide who you are. And some of the judges let people do this. They say, oh, it's not relevant. Well, yeah, technically it's not relevant. In reality, like if you allow someone who's just basically like a little legal shop misrepresent themselves as some spunky little startup, that's fighting a big company, that affects how juries decide these cases. And juries are good with certain types of prior art, like if it's product prior art and it's an anticipation, they get it. Like, here's this thing that existed before this patent was filed for, this already existed. But if it's an obviousness case based on patents and printed publications, Judge Albright had himself had a great quote about this recently, and he was quoted in Law 360 where he spoke at some forum, and his advice was, don't ever, 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 ever bring an obviousness case to a jury. Once you start talking about motivation to combine, you've lost them. I actually wouldn't be quite that negative, but the thing about juries, though, is there's no reliability. There's no consistency. You can have something that would be a slam dunk obviousness case at the Patent Trial and Appeal Board. People who understand what a semiconductor is and have a sense of these things would, you can advise a client like, yeah, this will definitely win at the PTAB if the art is strong enough. You can never make that kind of prediction in a jury trial. At best, they're unpredictable, and they tend to, again, like, be influenced by these narratives. Who's the big guy and who's the bad guy, and stuff like this. And it doesn't matter how strong your paper-based prior art cases. There's you're going to lose a good portion of cases, even if you have strong prior art, if you're repeatedly in the jury system. Whether you mentioned post-grant reviews earlier.
Yeah, please.
Just to be clear, you have to file a post-grant review in the first 9 months after patent issues, right? So the patent office has said part of the reason they're doing this is they want people to shift to PGR. Well, the patent office issues about 7,000 patents a week. So if a major company wanted to use post-grant review instead of IPR, you'd need to hire about 1,000 lawyers, review all those patents, and probably file about 200-300 post-grant reviews every month. If you think that's a practical alternative, you go there. And that, by the way, that's not even guaranteed it'll work. There's a lot of unpredictability about how patents are asserted, but you cannot challenge every patent that may be asserted against you within the first 9 months. It's not a practical solution. So I'm just kind of baffled that the office is going down this path, and really curious as to where it ends. I mean, the office is basically declaring war on about 90% of the U.S. Economy with this, and people often, it's hard to get people interested in patents issues. There's all this stuff going on with trade, but in about a year or two, when you get the verdicts coming out from these patents where people were denied access to validity review, that's when this is really going to flare up. By the way, someone pointed out to me one more rule that the PTO has just come up with. Apparently, in a board side chat, they clarified their guidance on expert testimony, and they basically explained, look, if you're really relying on expert testimony and there are competing experts, that indicates it's a case that's maybe better for an Article 3 court. And you should only be using expert testimony to explain terms of art. But if it goes to the core of a case, then that's a sign that we shouldn't be using PTAB review. Just to be clear, the statute expressly says you can use expert testimony in PTAB review. And to state an obvious point, if it's a complex case with a complex technology, that's exactly the kind of case that post-issuance review at the agency was created for. This idea that something that's expressly authorized in the statute and that's entirely congruent with the agency's expertise in reviewing now becomes a reason why you shouldn't grant review. I say, just scrap all these rules. It would make more sense if we use the moon phase system. At least that would be predictable. You know what the moon is going to be at a certain point, and we probably end up with about the same discretionary denial rate. And and at least it wouldn't flatly violate the statute like so much of what's being done here.
That's interesting about the expert evidence. I know there was, I'm sure that would be surprising to district court judges who have much less technical expertise in find sorting between expert testimony probably considerably more difficult than PTAB judges would. And I know there is at least one IPR where there was a different result in the district court than in the PTAB, and the district court specifically said, I don't really know what the experts are saying, so I'm going to kind of like go with credibility here, in terms of, you know, who I personally trust, because I don't understand the technology, and the PTAB, you know, did actually delve into it and reached a different decision. And so I think kind of confirming that a case that involves expert testimony is that complicated, it'd be one that'd be well suited to people with the expertise to understand the testimony. But I also want to ask you, Joe, we have one question about whether patentees and patent owners can initiate IPRs. And I wonder if you can say whether, if you know that's changed, but also like what the rationale is for why patent owners are not entitled to initiate their own IPRs.
Yeah, I guess, you know, they can initiate their own re-exams. I guess it was viewed as this is always going to be an adversarial tool with two parties in it. So, you know, how can you have one party on both sides of it initiating? I think that was the reason. You know, the real dispute was whether to impose any kind of additional standing requirement like adverse economic interest or anything. And you know, earlier versions of the AIA did have that kind of a standing threshold, and the reason for dropping it was largely to not overcomplicate the initial. You know, you don't want to have a mini trial and discovery just over whether you're going to hear the case. Just let people challenge it if they, you know, if they're not the patent owner and they have the evidence that the claims are invalid.
And I'll step in as a nonprofit with an interest in being able to, you know, challenge granted patents that are invalid and leading to, you know, harms like high drug prices, particularly maybe the orphan drug space, is that it's very hard, if not impossible, to do that in district court. And so the PTAB, you know, perhaps now is not a super viable form, but that option is important to have that in now. And I also, you know, I think there have been some cases where patent owners had requested re-examination, and, you know, when the patent comes out and stands up, then it's even sort of stronger and more robust. And so I had heard some understanding that also they wanted to make sure that the process wasn't sort of, there wasn't sort of gamesmanship of that kind there. But Chris, I want to ask you, we've been talking about like trials and PTABs, if you can, PTAB proceedings, if you can sort of give us a sense of like what the difference is in terms of, you know, cost and process, like what for you is sort of, yeah, the difference in the scale and reality of a PTAB proceeding versus district court.
Yeah, it's interesting. It's a great question. And one thing I just wanted to briefly correct is that if institutions denied in an IPR, you do get part of the fees back. You pay like a pre-institution and a post-institution fee. And so if you have a denied petition, you request a refund and you do get like about half the money back. I just wanted to clarify that. But on your question, I mean, IPRs are obviously much less costly. They're much less costly for the client. There's more of a, you could predict with a lot more accuracy how much they're going to cost. It's a pretty set, you know, process. You have a petition, you have a declaration that typically goes with that. You have very clear timelines in the statute that you have to meet. Usually have a deposition, you have an oral hearing, and you can predict with pretty good accuracy like how much that's going to cost the client, you know, with pretty good consistency. Now, with these new procedures, you are adding additional costs because the briefs, I think, are 14,000 words for this preliminary proceeding. And so they're almost as long as the merits briefing. So you're going to have more cost as a result of these new procedures that are going on. But district court is obviously, you know, a lot more expensive because, you know, in PTAB, you only have printed publications. In district court, you're usually going to have, you might have system art theories as Joe said, and I agree, system art does tend to be more compelling before juries. So a lot of times you'll want to have that, but that requires subpoenas. It requires a lot of workup. It requires a lot of fact discovery. And you know, the costs of discovery on the merits of infringement and validity is many, many times more expensive than doing the PTAB proceeding. And district judges in the US vary widely in their practices. cases can go on for years, rulings can take years because, again, there's no consistency, which is why there are certain judges like Albright and Gilstrap and others who plaintiffs like, because they have at least some predictability in the scheduling, whereas some of these judges from less frequent districts will sit on a patent case for 5 years and kind of treat it like a hot potato that they don't want to touch. So that's just the common reality. So yeah, the variance is tremendous between the PTAB proceedings and the nature of them. I would say they're both litigation, they're both trials, and it's important to have good litigators doing both. But it is very, very different, and it is a different audience. I mean, that's the other key thing. I mean, the technocratic arguments are obviously a lot more effective with the APJs than they are for a jury, which might put them to sleep, as was also stated before. So that's what I'd say as an overview there.
Thanks, Chris. And curious, Greg, if, hearing about, litigation, if you had a world where, every application, gets granted and you just kind of have it play out in the federal district courts, what does that mean, I guess, for patent applicants, and does it mean different things for different types of patent applicants?
Well, I mean, the advantage is in the hand of the applicant, right? Because it's presumed valid. So really what we're looking at is the public at large. And that's one of the reasons it's a difficult topic, right? It's hard to measure, right? It's hard for me to go out and say, how many millions of dollars did this bad patent cost? And people have done research on that, and I appreciate that, because we do need to try to figure out what that number is. But it would be primarily on just any company of any size that has one of these patents asserted against it. And some of these patents that come out, you can't figure out what they're even about, right? Because somehow they got through the patent office, and it's not a criticism of the patent office. Is sometimes these folks are very clever in the way they word these things, and they have, lots of resources to throw at the problem, and the patent office has a limited amount of time. So as much as we would like to improve quality to a point where we wouldn't need the PTAB, it's just about impossible to do that, just because of the complication, as was said before. Just getting up to speed on that technology in the first place could take weeks. And we're expecting the patent examiner to look at something that has never been done before by definition and figure it out. So that's the way I would answer that.
Thanks. That makes sense. I'm going to go through and kind of ask folks for another, last takeaway. So I think maybe, Julie, starting with you, is that, there's a lot happening, and I guess particularly in the examiner front, like what do you think is kind of most important for folks to know about in terms of what changes are happening and what that means for examiners?
Very good question. Listening to everybody else on the panel, a lot of very interesting points. The thing I see missing from this discussion, it seems that we're giving the Patent Office an awful lot of credit for having come up with all the changes that we're facing. And usually it's a backwater organization that kind of runs along and nobody's of much interest. This administration has a great deal of interest in the patent system. And the changes that we have seen in the CDC and the FDA and the NIH should be very illuminating as to what is going on here and now. I have understood that the plan is to bankrupt, skeletonize, break down the agencies to their bare bones essentials, to prove that these agencies are not competent to perform their administrative duties, which should then be privatized out, and have the issues turned into something as simple as registration so that everything gets resolved in the courts. This is not just something about the patent office or about the particular leadership of the patent office right now. We're looking at a very big, deep picture, a pivotal change going on here. And the idea that things will run through the office faster, the rejections and the allowances. There will be a limited review for correcting issued patents. I understand much of the re-exam and reissue branch has been either retiring out or coming back into the tech core to examine. And the PTAB, I know, Joe, you said it might just take 100 APJs, something like that, to keep the PTAB functional. there's been a recent announcement that the appeal side of the PTAB is going to be given preferential treatment. And it's of much more importance to get the appeals done in a timely manner. And so APJs that are working on the IPR issues have been transferred over to work on appeal issues. I think we should look at the remedies to correct errors in patents to be disappearing from the patent office. I just see it coming our way. And I don't know where the patent bar is and where the public is. I don't know where, thank you, Alex. So appeals are appeals of rejections. If the examiner's rejected claims, the applicant can appeal up and try to get the appeal branch. And it's been long in place way before the PTAB existed to correct poor rejections, challenged rejections. So I think these things are very at the fore right now. We are definitely in the crosshairs right now. And it's a very interesting time to note. My final point is any suggestions for changing the agency using AI or technology to help with the search and the examination. I know that that's out there in the business arena and you could get great efficiencies doing that. I think we really need to take a stone cold hard look at the state of the Patent Office IT system, which crashes near daily, which cannot handle the workload, the functions already on hand. The Biden administration, as part of their infrastructure build out, gave the IRS $79 billion over 10 years to update the antiquated IRS IT system. The Patent Office system probably needs that level of money thrown at it to fix their IT systems. And I don't see that coming from inventor filing fees. I don't see there's any way that we can ourselves as a standalone user agency do this without having some outside input of money. And I know how glamorous it is to think of AI and replacing examiners with AI, but were you to install AI-driven search and examination tools onto the USPTO's current IT system, that would be about as wise as putting some cruise missile launchers on the decks of the Titanic post iceberg.
Thank you. Thank you, Julie. I'm going to turn that over to Joe. What do you think are the big takeaways of what's happening at the PTAB?
I'll be brief. In the short term, this is, good for lawyers, creates more work for lawyers like me. We're probably going to see the golden age of the patent troll, over the coming year. In the long term, if they stay on this path, and by the way, I'm pretty sure this isn't, some, top of the Trump administration vision that's being implemented here. Before the Commerce Secretary was announced, the White House was looking and going in a very different direction with patent policy and a very different leadership over there. The current direction seems to be purely a function of the current Commerce Secretary and his predilections. And if we continue to go down this path, it's going to do an incredible amount of damage to the U.S. economy, and over the long term, if they stick with this, it's going to damage the legitimacy of the patent system. I think in the years to come, it'll be viewed as a grave error to have taken these decisions.
Thank you. The golden age of the patent troll. It's a harbinger of scary things. Turning it to Greg, can you tell us what sort of your takeaway is?
Well, sort of like I was saying, that the patent is a restriction on the public's freedom. In a way, it's sort of a flavor of legislation, right? It's sort of like we've looked at this and we decided you can't do this. You are prohibited from doing this. And the force of the government will be put into place to make sure that you don't do this. Yes, there are licenses and all this, but at the end of the day, you can't do this. Is that something that we would want to outsource or to turn over to ChatGPT? Just go home tonight and ask ChatGPT to draft a law. What's going to happen? You can just kind of predict, and we have to represent the public interest. That's the Public Interest Patent Law Institute. But that is the whole point of the patent system. Again, it's this elaborate gifting system, and if it doesn't work, I think we were at a point maybe about 10, 15 years ago, 15 years ago, where folks are really complaining about the patent system. We've worked really hard to try to move it in the positive direction. If if it gets to the point where it doesn't work, then it's going to be called into question completely, and then it'll just be I don't know what's going to happen. I would like to see a plan. If there was some sort of a plan in place, then I would feel a lot better, like others have said, about predictability and investment and trying to figure out what to advise clients. So right now, the patent office, the patent community is used to having lots of planning, and we don't have that. So maybe we have a little bit of anxiety going on. So I'll leave you with that.
Thank you. I think that's absolutely true about the sort of psyche of the patent world. Chris, I'd love to hear what you think the big takeaway is.
Well, I would just ditto the comments about AI because I do think that is a particularly strong interest of this administration, and I'm curious how that plays out, both in terms of addressing the issue I'm troubled with as well about how they're not examining in as robust of a way and removing NPL and all of that. But is there a place for AI, not to replace examiners? I don't believe that, but like to, help examination be robust and be meaningful. Because that is an opportunity, I think, for us from an innovation standpoint. And I'm curious about that. And I'm also curious about how things go on the other side in terms of the AI inventorship question, which was kind of put out there. There was some guidance from the last administration. We haven't heard much from this administration about that. And that's going to be a very fascinating question of what happens. Obviously, there were some comments in the media about deleting IP law recently. The current interim director has responded to that, implicitly at least, it seemed, and said, we believe in innovation, we believe in all these ideals. So I'm curious to kind of see how that plays out from a policy standpoint. One other comment I wanted to make too, as someone who does a lot of appellate work, federal circuit appeals too, is I am interested in the dynamic between how these denials play out vis-a-vis the federal circuit, because when I clerked, there weren't IPRs. It was right before they started. And the federal circuit judges have really been bogged down by the number of IPRs, and it's something you hear from time to time. And so I'm just curious how that plays out, because the timeline to decision in the federal circuit has got longer and longer and longer for the last several years. It actually is another problem in the patent system, and it's complicated by other factors that are outside of the scope of this panel. But there's an interplay there as well that I'm curious how that plays out, assuming the premise that more denials are going to happen does occur. So those are the things I'm really thinking about right now.
Thanks, Chris. I'm going to turn to Professor Wasserman, but I do want to quote just something from the president's executive order on drug prices recently, which was that Section 2 says it's the policy of the United States that federal healthcare programs, intellectual property protections, and safety regulations are optimized to provide access to prescription drugs at lower costs to American patients and taxpayers. So it's an interesting look into what one policy is. But yeah, Professor Wasserman, would love to hear what your sort of takeaway is at where the patent system, where it stands, where it's going, particularly in terms of quality and the impact on in the health sector.
Yeah, I mean, I agree with what some of the other panelists said. We made a lot of changes, right, with the AI system, right, to kind of beef up quality and to provide, right, this cost-effective way to revisit patents that were erroneously allowed, right? And we've always had, right, the adjudicatory board to revisit erroneously denied patents. And I think what we're hearing is really concerning, right? It's diminishing quality, right? It's allowing more, it seems setting up a system to allow more questionable, low quality patents to be issued, and all of the harms that are associated with that will just come back. And in particular, right, in pharmaceuticals, it's a concern, right? Each additional day, right, that could be on the market could be hundreds of thousands of dollars, right, that we're paying for drugs that arguably shouldn't be covered anymore by a patent.
Thank you. Thank you all. Thank you to our panelists so much for attending and for this. I learned a lot. I'm sure our attendees have as well. Thanks to all attendees for coming, and we look forward to having more discussions, and the recording will eventually be posted. And so for folks watching it that way, thank you too. Thank you, everyone.
Thanks.
Bye.